Hey, it's Jeremy with Civitas Law Group. I got a lot of requests for the Lincoln Lawyer. All I knew about was the old Matthew McConoaughey movie. Apparently there's a new Netflix series, or at least it's newish. So we're going to be reviewing that today. Episode 1, Court's in Session.
The private chambers of a female judge is A, you have a case before her, or B, you have a personal relationship. And since you haven't had any cases at all for like a year.
I never even met the woman.
Well, she wants to meet with you, like now.
Okay, so that actually starting off with something pretty legit right there. The only reasons you would be called to the private quarters of a judge is if you have a case before her. Yeah, and she's saying a female judge. I'm going to go ahead and say any judge, and not, is she saying the private quarters? I think what she actually means is the offices in the back, so the chambers. But anyway, yeah, if you don't have a case before a judge and they call and say, I'd like to meet with you, I would be saying, okay, so we're meeting at Starbucks, because clearly I'm not seeing you as a judge in your role as a judge. I'm seeing you as a person. So what, Starbucks or my office, Burger King, where do you want to meet? If I get called to the chambers of a judge I've never had a case in front of or don't currently have a case in front of, and if the other attorney is not there, I'm going to be really suspicious about what's going on. So starting off with something pretty real.
We've met before, have we?
No, Your Honor.
No. Come on, then. The Lincoln Lawyer, that what they call you?
Some do, yes. Or did.
Why?
Mainly worked out of my car, going from court to court, all the driving and so forth.
So right here, I'm already going to be suspicious and uncomfortable, because he went into the courtroom. The judge is actually wearing, her robe, which, generally is a sign that, court is in session. Judges, if you see them back in chambers, sometimes they're in jeans. They might be wearing jeans and a t-shirt underneath that robe, and they're just totally chillaxing back in chambers. But even then, they're not going to want you back there without the other attorney present. She's got her robe on. He shows up. He invites her. She invites him back to chambers, and there's no other attorney present. So already, I would be super uncomfortable and be planning my exit, going, I really don't want to be talking with this judge about legal things while she is in her role as a judge and in her chambers with no other attorneys present. Awkward situation. So let's see what's going on.
Assuming I'm satisfied that Mr. Vincent's clients are being transferred to a replacement counsel of good standing and competent skill. As far as I can tell, you haven't had any cases in quite some time.
I was in an accident about 18 months ago. Surfing, if you can believe it. I had multiple surgeries, and, well, there were complications.
Complications?
I took painkillers.
Okay, so just a second ago, it sounds like the judge was saying one of his cases, a very famous case, it sounds like, is being heard in her courtroom, and now he is the assigned attorney because he inherited this case from this guy that just got shot in the first scene. That makes this whole situation even more awkward, because she is saying, you might be the attorney on this new case, or on this case that's being heard in my courtroom currently, and I'm talking to you without the other side present. In this case, it sounds like he's a criminal defense attorney, so the other side would be the prosecutor, and they are having this whole conversation, what we call ex parte. Only one side is actually present in the chambers. So this conversation would, technically speaking, he's not the attorney on that case yet, so maybe you could get away with it, but I don't think any judge in the world is going to say, or at least not in the United States, is going to say, yeah, come on in and talk with me without the other side present. I don't care what the prosecutor says. We're just going to, I'm going to interview you and see if you can move forward with this case. Yeah, I don't think that's going to happen.
What was that?
Oh, that wasn't meant for you. But if you heard me, you heard me.
You're contaminating a crime scene. You can't be here.
This order will confirm I've been appointed by the presiding judge of the Superior Court as replacement counsel to Jerry Vincent's clients. That means his cases are not my cases, and you have no right to be in here looking through files. That's attorney-client privilege.
Mr. Vincent's been murdered. The motive could be in one of these files.
Even if that were the case,
Counsel.
Just read the order, detective. Your crime scene is out in the garage, and no judge in LA would extend it to this office and these files.
So some real and some fake here. The real is everything that the attorney is saying. Those files are all attorney-client privileged, and no judge in the state or the county or wherever they're at is going to sign off on a warrant to just search through files just saying, well, a motivation could be in one of those files, so we need to have a look. To break attorney-client privilege, even after the attorney is deceased, to break attorney-client privilege takes a really big deal and a lot of probable cause. It can't just be, there might be some motivation in there. It would have to be, hey, it all points to this one file. We want to have a look at that one file, or maybe even 3 files, something like that. But they've got to have more than just, we're going to search his whole dadgum office, tear the place apart, and look through every file in there. That's not going to happen. Yeah, so the fake on that is that the police are already there rummaging through it all just because the owner of the law firm is deceased. Attorney-client privilege goes to the grave. The attorney dies, he can't tell anybody, obviously, but those documents are all still privileged. If the client passes away, attorney-client privilege still carries on. In most, if not all cases. I remembered maybe a couple little exceptions back from law school, but I've never even had to think about one of them. So the police really probably wouldn't even be here at all. This argument probably wouldn't have to happen. If it was going to happen, it'd be happening with a judge at the courthouse, with them trying to convince the judge, hey, we really need a warrant for this issue. But for this whole broad spectrum, yeah, we want to look through every file in there. It's not going to happen.
You gonna get out of here, or do I need to call the judge?
Guys,
Nice to meet you too.
Bye.
let's go. Leave everything.
What? Come on.
Fun little subtopic right there. Technically speaking, he did just admit to murder. You could see from the clip that he's doing it really sarcastically, and so not every admission is actually a full admission. There have been people that have said, oh, he admitted to this crime, and then when you go and read the statement, it's like, no, he admitted to being in the area. When you asked him a question, that wasn't an admission. Anyway, not every admission is an actual admission, and thank goodness for some people, because this TV attorney did not do what every other attorney in this situation would do, which is to say, do you know what? I'm going to take the fifth and get counsel. You think that attorneys in that situation are going to go, oh, I know the law, I'm fine, I'm going to push forward? Heck no. We're all going to say, I take the fifth and I want to get counsel. Especially because it's an emotionally charged situation. You want somebody next to you that's not emotionally charged saying, if I'm in that situation, Jeremy, sit down, shut up, let's talk about this and see what they actually have before you say anything.
That would be Mark Daniels, who I'm covering for, so that's actually mine. Grand theft, by the by.
Obviously, I'm gonna need a continuance.
Obviously, I'm not gonna give it to you.
What?
I got out-of-town witnesses. I'd rather they be pissed off at the judge or you than me, especially if I want to get them back.
LA 292587.
So just FYI, and I've seen other shows that have kind of tried this same thing, where the prosecutor will say, I'm not going to give you a continuance. Prosecutor doesn't give a continuance. The judge gives a continuance. The prosecutor can object to it, but if you have a really good reason for one, as in his lawyer, the lawyer that he hired, just got shot, and I don't know anything about his case, that's a really good reason for a continuance. This guy's going to get a continuance. I don't know if he's actually going to get one on TV, but in a real situation like that, he's getting a continuance. And a continuance, by the way, just means we're rescheduling this, pushing it down the road because you need more time.
Your Honor, Mr. Vincent unexpectedly passed yesterday. I'm filling in.
My sincere condolences. When will you be ready?
Well,
Don't be greedy. It's a bench trial with 2 witnesses.
Out-of-town witnesses, who I'm at risk of losing with the continuance.
How's tomorrow?
tomorrow.
Yeah, how's tomorrow? Get ready for a trial in, 24 hours? No. And like this happens on TV dramas all the time because we love it. Like we love to see that they had to stay up all night long and get ready for this trial. Never have I seen that before. When I have heard judges say, hey, look, we've already pushed this out as far as we can. I'm sorry that you don't have a lot of time, but it's a time frame like, how's 2 weeks? Okay, it's not 24 hours. That's insanity. And the judge wouldn't do this because he's setting up an appeal for this defendant. My attorney got shot, and you gave my new attorney 24 hours to get ready for the trial. That's an appeal. So, yeah, that's not going to happen, but hey, let's see what happens in the rest of the conversation.
I snatched the necklace and ran. I did not attack her.
Okay. Is there a reason Jerry didn't try to plead this?
Because they wanted 2 years. And Jerry said it was excessive. He thought with the trial I could at least impress the judge with my extenuating circumstances.
So interesting there. She snatches a necklace, presumably off of a person. If it's actually on her neck, let's picture that, right? She snatches the necklace off of her neck and runs, and she's thinking, oh man, 2 years, that's a lot for that. Well, technically speaking, there's 2 crimes committed there. Okay, there's an assault because she had to snatch it off of her person, so contact was made with the person. The assault occurred during a felony offense because that necklace looks like it's worth a ton of money, and they did say it's grand theft, which different states call it different things, but theft can go from misdemeanor all the way up to felony depending on how much was stolen or the value of what was stolen. And so since it occurred during the commission of a felony, you've got an aggravated assault there. And so 2 years, not a bad deal, honestly. I might have been telling the client, hey, we at least need to think about this deal, since she is just openly admitting, yes, that's absolutely the way it happened. There may not be much of a defense. So 2 years is actually a plea that she should be thinking about, bare minimum.
I'm a good person who had a drug problem. It wasn't me who stole that necklace so much as somebody I don't even recognize, somebody who's gone. I went through rehab. I'm in recovery.
I believe it.
Okay, next. She's saying the other attorney didn't want me to take the plea because she wanted to present my extenuating circumstances to the judge. Okay, you can actually do that without trial. There is a process, at least here in Arizona, we call pleading to the court. You can plead to the court. In other words, you can tell the court, I'm guilty. I'm not taking their plea agreement. In fact, we don't have any agreement with the state. Not always available, but frequently you can plead to the court and say, I think I'm going to do better telling you, the judge, about my extenuating circumstances, or in other words, we call mitigating factors. Now, the fact that she had a drug problem is not an extenuating circumstance or a mitigating factor that I would say is worth turning down a plea like 2 years. I would probably be telling her, no, you need to seriously think about that, because it could get worse. If you say, I have a drug problem, the court could go, oh, okay, so then you're admitting that in addition to your aggravated assault and your theft charge, that you should have been charged with drug possession and use also. Now, it very likely wouldn't happen in those circumstances. And I have said, yes, hey, this crime was tied to a substance issue, but I will very carefully say a substance issue and not say a drug problem, because that sounds more like a crime. Say a substance issue, which my client has already taken a lot of steps to mitigate and to handle. I have had clients that have come to me and said, yes, I committed a theft, and yes, it was driven by my drug problem. But this one client that I'm thinking of in particular told me that after he had already been to detox, after he went to inpatient rehab, out-of-patient rehab, and then went to a sober living facility. In that case, you could say, yeah, look, there was a drug problem, was an underlying issue here, but it's been handled. This isn't going to be something he ever does again. Don't know if that's the case here. I would probably still be telling this client, let's think about the plea.
Mr. Elliott?
Stand trial for murder next week. My attorney's just been shot dead. You can probably imagine how I might be doing.
All right, I know I might be beating a dead horse here, but if you're on trial for murder next week and your attorney just got shot, they're probably moving that trial. That's definitely an extenuating circumstance. That is definitely a situation where the judge is going to go, yeah, we've got to move this trial. Yeah, this guy's not going to trial next week. I know I'm beating a dead horse, but you're getting a continuance.
The client is charged with grand theft, which under Section 487 of the Penal Code means the value of the stolen object exceeds $950. Your Honor, that necklace is worth what? 400 tops?
What?
Yeah, I've taken more than a few payments in diamonds and gold, developed a pretty good eye. But to be sure, Judge, I also brought with me an expert on the matter. That man over there is Marvin Beetleman. He's a jeweler. He can give us a pretty quick appraisal. I realize the district attorney might want to get one of her own. I'm guessing your wife doesn't know it's a knockoff. I, of course, don't want to upset her.
Are you kidding me? Are you kidding me?
I am not. I am not.
Hold on.
There's a whole lot more in the episode here, but I could go through this probably for hours. I mean, there was actually a lot going on. I'm going to look forward to doing more episodes of Lincoln Lawyer, but this first episode, we're going to leave it right there. Let me know if you have any questions on it or if you want to see more episodes of it. Let us know in the comments. Otherwise, we'll see you next time.